Oui. Ladies and gentlemen, I think it's time to start our afternoon session with a slight delay, but everything is under control. And we continue in the same context. It means from global to local. Now we are addressing more the local side and the national litigation which is taking place before national court. Of course, there is no international law without national law. I mean, the international law is implemented, applied by the states, by the organs of the states, including judicial authorities, and the practice of state is also leading to development of sources of international law, customary law, general principle of international law. Therefore, it's quite normal to have different expose statements addressing the practice of climate litigation before national courts. And we have 5 very interesting topics to be addressed and 5 panelists who will enrich our discussion. Without further ado, I will give the floor to Mr. Spijkers. Otto Spijkers is Assistant Professor of International and European Law at Leiden University College. And before joining Leiden, Mr. Spijkers was Professor of International Law at Wuhan University in China. And before that, he worked at the Utrecht Center for Water, Oceans and Sustainability Law, and his doctoral thesis was relating to the UN, the evolution of global values and international law, and it was presented at the Grotius Center for International Legal Studies at Leiden University. This Mr. Spijkers has all credentials, and please, you have 15, 20 minutes maximum, and thereafter we will have enough time for a session of question and answer. Thank you.
Yes, indeed. I was told we have a slightly stricter chair now compared to before the lunch. So I will limit myself to 15, 20 minutes max. I do have, oh yeah, okay. So I have to operate them myself, right? Yeah, okay. So my lecture is about, it's very local. It's actually about litigation in the Netherlands, my home country. But of course, because we have such an open jurisdiction, it's actually a lot about international law. Hey, that's me. Can I have the slides back? I mean, I like to look at myself, but maybe the slides are more interesting. So you start the timer now, right? So yes, in the litigation I will refer to, I will discuss with you a lot of references made to the European Convention on Human Rights, and then in particular Article 2 on the right to life, and Article 5, which basically is the legal basis for the right to a healthy environment in one or other shape or form. So I will talk a lot about public interest litigation. So the Urgenda case and everything that is inspired by it and followed it, they are all public interest litigation cases. So they are all initiated by a foundation established under Dutch civil law, purporting to act in the general interest, whose aim is to influence public or corporate policy rather than get compensation for itself or for its constituency. So using the courts to influence public or corporate policy in this way is called public interest litigation. And this has increased in popularity in recent times, in part because of the success of the Urgenda case. So let me freshen up your memory quickly before I turn to what's next. So climate litigation is a subcategory of public interest litigation. And the best known example in the Netherlands is still the Urgenda case. So Urgenda is a foundation established under Dutch civil law, to protect the current and future generations of the Netherlands from dangerous climate change. And Urgenda began its case against the Netherlands already in 2012, so a very long time ago. So we first had a ruling by the district court in 2015, then the appeals court in 2018, and then the case ended at the Supreme Court level with a ruling in December of 2019. And briefly put, the Supreme Court of the Netherlands then held that the Netherlands government must ensure that greenhouse gas emission levels from the Netherlands are significantly reduced. Otherwise, the duty of care, inter alia informed by these two provisions of the people of the Netherlands, will be breached. There's a lot to say about the Urgenda case, but I want to focus on one aspect of it before moving on to the next. And that's the references to the interest of future generations, because there's a lot of misunderstanding about this. So the appeals court is the most pronounced. The appeals court ruling is the most pronounced on this issue. And the court said the following, and I do want to quote. So the state of the Netherlands argued that Urgenda cannot act on behalf of the future generations of Dutch nationals. In view of the appeals court, the state does not really have an interest in that ground of appeal because Urgenda's claim is already admissible insofar as Urgenda acts on behalf of the interest of the current generation of Dutch nationals. After all, and now I read from the slide, it is without a doubt plausible that the current generation of Dutch nationals, in particular but not limited to the younger individuals in this group, will have to deal with the adverse effects of climate change in their lifetime if global emissions of greenhouse gas are not adequately reduced. So basically the court is saying, no, this is not a case about future generations' interests, it's a case about present generations' interests. So and the Urgenda case does explicitly not deal with future generations' interests. So what happened after Urgenda? There's three cases that I'd like to focus on. First is the Shell case, then there's a case against the Royal Netherlands Airlines, KLM, and then there's a case against ING, a major bank, also based in the Netherlands. And if time permits, I will also say a few words about the Bonaire case. So all these cases that I will mention from now on, they're all still pending, so there's no final ruling yet. So let me begin with the Shell case. In 2018 already, Milieudefensie, that's Friends of the Earth Netherlands branch, they began a case against this giant global oil company that everybody knows, Shell, which was at that time still headquartered in my hometown, the city of The Hague in the Netherlands. And then in May of 2021, the district court delivered its judgment, basically agreeing with Milieudefensie that Shell was doing too little to reduce greenhouse gas emissions and prevent serious climate change, damage. So I guess the Shell was not very pleased with this ruling, so they immediately relocated their headquarters to London to avoid further climate litigation. But of course, these proceedings, they will continue. So they're now on appeal. Actually, we already have an appeals ruling, but first I want to say something about the district court ruling. Because on Milieudefensie's claim that it was representing the interest of future generations, the district court had an interesting thing to say. It said, the interests of current and future generations of Dutch residents are suitable for bundling in a class action like this one, even though in the Netherlands there are differences in time, extent, and intensity to which the inhabitants will be affected by climate change caused by CO2 emissions. So again, the court has no problem bundling the interest of present and future generations and really did not see a difference there. So again, this is not a case about future generations' interests. So on appeal, and I think this is interesting to mention, two other foundations joined in the proceedings, and they are Clintel, a bunch of climate deniers, so they deny the climate science. And then there's another foundation, the Stichting Milieu en Mens, Environment and Man, or Humankind. And they wanted to present the interests of all Dutch citizens who are more interested in being provided with energy security rather than a healthy environment. So I quote from the press statement of Stichting Mensen en Milieu. Milieudefensie initiated the proceedings in the general interest, but the M&M Foundation, a bit awkward abbreviation of course, argues that there is much more to the public interest than just the climate interest, and that these other interests have not been taken into account by the court. We want to introduce these aspects into this case by intervening. So it echoes a bit what our chair said before the break, that not all foundations are the good guys. There's also bad guys that may engage in climate litigation. So on the 12th of November of last year, the Hague Court of Appeal ruled in the appeal between Milieudefensie and Shell, basically ruling that Shell has an obligation to Dutch citizens to limit its CO2 emissions. And this obligation, and that's quite revolutionary, stems from the human right to a healthy environment, which includes, according to the court, protection against dangerous climate change. So while it is primarily the government's responsibility to ensure the protection of human rights, of course, we all know this, these rights, according to the court, also indirectly impact the due diligence that companies like Shell must observe. So according to the appeals court, from international human rights law also derive obligations for corporations like Shell. So that's the good part of the ruling, but the bad part is that the Court of Appeal did basically dismiss all of Milieudefensie's claims. And the reason being that the Court of Appeal could not establish that due diligence requires Shell to reduce its greenhouse gas emissions by a very specific percentage, 45%. And that is what the claimants had asked for. So they lost on appeal, and now the case is before the Supreme Court, so the ruling is still pending. And now I want to look at another example, that's the fossil-free lawsuit. So fossil-free, again, another foundation established under Dutch law. They started a lawsuit against Royal Netherlands Airlines, de Koninklijke Luchtvaartmaatschappij, for misleading sustainability claims, or what's more commonly called greenwashing. And the question was whether KLM misled its consumers when this airline advertises its green activities. And I just wanted to show you some examples of this greenwashing. So here, no, where is it? Yeah, so here you see, it's a bit difficult, but there's a shadow of an airplane there. So you see an airplane flying over these green fields, as if there's no environmental problem. And the most interesting, I think, and the most particular is this advertisement, be a hero, fly CO2 zero. Basically suggesting that the more you fly, the better it is for the climate. Of course, I flew from Amsterdam to Rome on a KLM airplane, so I'm making my contribution. I always wonder which brilliant mind comes up with these slogans, be a hero, fly CO2 zero. This is, of course, not an ad from KLM. So this is from the website of the claimants, Fossilvrij Nederland, basically making the point there's no such thing as sustainable flying. There is a final ruling, or no, there's a ruling on the merits, I should say, but only from the Amsterdam District Court in this case. And the court ruled that the number of advertising statements made by KLM in the past were indeed misleading and therefore unlawful. And this Be a Hero campaign, that was actually stopped because of this climate litigation. And on November the 6th, so last week, 21 major airlines committed themselves to change their practices regarding environmental claims that were considered misleading by the Consumer Protection Cooperation Network. So you see the impact of climate litigation very clearly. So all these 21 airlines, including KLM, they have committed themselves to stop claiming that CO2 emissions of a specific flight can be neutralized, offset, or directly reduced by simply paying a sum of money, a financial contribution to climate protection projects like reforestation. That's a fraud, and the airlines have now acknowledged this. And of course, the climate litigation has played a big role in that acknowledgement. Yeah, I do want to say something about fossil-vrij's claim that they also represent future generations, because I thought this would be an interesting common theme. So if you look at the Articles of Association of Fossil Free, you see that their purpose, it's in Dutch, so I will translate it for you. You can understand, but most people will not be able to understand. So the foundation's aims of the foundation is to aim for the benefit of current and future generations to promote, protect, support, and achieve social, environmental, and economic justice, and health at the local, regional, and national level, and to remove social legitimacy of coal, oil, and gas companies, the so-called fossil companies, and airlines are often included in that category. So on the 7th of June 2023, the Amsterdam Court already accepted that fossil-free could legitimately claim to represent both current and future generations. And there's an interesting paragraph justifying that conclusion. So I again quote the originals in Dutch. I will provide English translation. So fossil-free represents all natural persons living in the Netherlands at the time of the summons, and those who are born and come to live in the Netherlands after the date of the summons. So those are the future generations who are affected by climate change. These natural individuals cannot be individualized, especially now that fossil-free includes all future residents of the Netherlands as part of this group. The action of fossil-free is essentially a general interest action, and in the context of a general interest action, it's not feasible for the interest organization to name all its supporters, let alone to make it clear that it concerns sufficient persons with a view to its representativeness. It's a bit of an understatement because it's not only hard to do so, it's actually impossible to name all your future supporters because they are not yet in existence. But the court did accept that fossil-free could also represent their interest. Then I want to talk about another case. How much time do I have? Okay, I can talk about two more cases then. So let me turn to my third example of post-Urgenda climate litigation in the Netherlands. So this is a case, again, initiated by Milieudefensie, so Friends of the Earth Netherlands. They also initiated the Shell case. And this time they demand of ING, a big bank based in the Netherlands, to halve its total emissions and stop collaborating with polluting companies that jeopardize our future. So these large companies include companies in the industrial and aviation sectors, but also oil and gas companies that continue to expand their projects financed by ING. So ING is currently reportedly investing around 26 billion euros in companies that are still developing new oil and gas fields all over the world. And it also has dozens of deals running with oil and gas companies that will continue to develop new fields even after 2040. So now you might wonder, does a financial institution like a bank, the ING bank, does it actually emit greenhouse gas? It's just people behind computers, right? Well, no, of course not. They don't emit much greenhouse gases themselves. So it primarily concerns financed emissions. So that refers to where the situation in which a financial institution's money is invested, for example, loans to companies building gas-fired power plants are offered. And that accounts for basically all of ING's emissions. 99%, 99.9% of all emissions are produced in this way. So this case has only just begun, so there's no ruling yet. But the argumentation is roughly the same as that was used in the Urgenda case, and it's the same lawyer who is behind it. But what I find interesting is already now ING is starting to sort of protect itself legally. So now if you go to the website of ING, they basically already acknowledge, so although we finance a lot of sustainable activities, we still finance more things that aren't green. but we're always looking to take our next step to drive further progress to a low carbon future. So they're basically acknowledging, making public to all of us that most of the finances are not green, but in the future, we're working on it. I think I have 1 minute left. So, this Bonaire case, it was initiated after the deadline for submitting my slides. So I don't have a slide, but this is a slide about Bonaire. So it's a Caribbean island that belongs to the Kingdom of the Netherlands. So just imagine a beautiful tropical island, okay? That's the Bonaire. So the Caribbean island of Bonaire is a municipality of the Netherlands, a gemeente, like the gemeente Den Haag. But it does not enjoy the same climate change protection as the Europe-based municipalities. Billions of Netherlands dollars, or euros rather, are spent protecting the Dutch coast from rising sea levels, but there's no comparable plan to protect Bonaire from rising sea levels, floods, heats, storms, tornadoes, hurricanes, and so on, that the residents might suffer in the future and are actually already suffering. So the plaintiffs, it's Greenpeace actually this time, but also a few individuals living in Bonaire. They argue that the Dutch government is committing an unlawful act to them by failing to take adequate climate action with respect to Bonaire. And they again base their claim on the alleged breach of the right to life and right to a healthy environment as protected under the European Convention on Human Rights. But they also allege that the Netherlands is discriminating them by not offering protection to them and offering protection to people in the European part of the country. So yeah, this will be one of the first climate litigation in the Netherlands that is initiated after the advisory opinion of the International Court of Justice that we heard so much about before the break. So that may be very interesting in what way the plaintiffs and later also the court makes use of that advisory opinion. So again, no ruling yet. This is really a case that has only just been initiated. So thank you very much for your kind attention.
Thank you very much for this overview of climate litigation in the Netherlands, and thank you for staying within the 21 minutes allocated. Well, we move from the Netherlands to France, and I have the pleasure to give the floor to Sophie Martin, who holds a PhD in international law from Sapienza University in Rome, and you are contributing to this Council of National Research, and you also collaborate in environmental matters with the University Sapienza in Rome. You have the floor. Thank you.
Thank you, Professor Gautier, for introducing me, and good afternoon, everyone. I would also like to thank Gemma Andreone for a kind invitation to participate in the conference today. I'm very honored to be here with you today and to present you the France perspectives in the field of climate change and biodiversity loss. Over recent years, France has seen a very increase in its case law on climate change and biodiversity loss. And this trend reflects both the growing urgency of environmental challenges and the increasing willingness of courts to look closely at public authorities' compliance with national and international obligations. So in the field of climate change, there are two landmark cases in France, Affaire du siècle of 2021 and Grand Sun case of 2022, where the courts have confirmed state obligations to respect climate targets and to implement effective mitigation measures. And I will come back to that later in my presentation. And parallel to this, in the field of biodiversity, we observe that biodiversity litigation is expanding in France, and cases increasingly challenge insufficient protection of ecosystems, spaces, and natural resources. And courts have begun integrating biodiversity concern with climate and health dimensions, acknowledging the interdependence of these issues. Thus, French climate and biodiversity litigation is at the intersection of environmental law and human rights, while contributing to the gradual construction of case law on environmental responsibility in France. So first, in my presentation, I will present the set of norms that compose the legal framework, and then I will discuss some key cases related to climate mitigation, climate adaptation, biodiversity loss, and also criminal investigation. So in the field of environment and climate, France adopted various documents. The first one is the Environmental Charter, which has been incorporated in the French Constitution in 2005. It recognizes everyone's right to live in a balanced environment that respects health. It introduces key principles as a precautionary principle and public participation in the decisions impacting the environment, as well as a mechanism of reparation in case of damage caused to the environment. There is the law on energy transition for green growth of 2015. It provides for the reduction of greenhouse gas emission by 40% by 2030, recognizes the development of renewable energy and the need to reduce overall energy consumption. We have also the law on energy and climate of 2019. It sets the target of carbon neutrality by 2050, plans for reducing nuclear power share in the energy mix and boosting renewable energy. In 2021, the law on climate and resilience has been adopted. It introduces measures to limit soil artificialization and threaten climate adaptation. And there are also two important documents: the National Low Carbon Strategy, introduced by 2015 law on ecological transition. It has been also revised in 2020 and is currently in preparation the third version. It is France's strategic roadmap for addressing climate change. It pursues two key objectives: achieving carbon neutrality by 2050 and reducing the carbon footprint associated with consumption. The other document, the National Adaptation Plan to Climate Change of 2025, it outlines a set of action to help France adapt to the current and expected impacts of climate change, with particular emphasis on the territorial dimension and the financing of adaptation measures. Then, in the field of biodiversity, we have the law on restoration of biodiversity, nature, and the countryside of 2016. It introduces the notion of ecological damage, requiring compensation for harm to the environment, strengthens species protection, measures against land artificialization, and environmental governance. So after having seen the existing norms in the French system, I would like now to analyze some key case law. So the first one, Affaire du siècle, before the Paris Administrative Court of 2021. The case has been brought by NGOs, including Greenpeace, Oxfam, and Fondation Nicolas Hulot. Here, the court recognized state responsibility for climate inaction, for failing in the fight against climate change, and for exceeding its carbon budget. The court acknowledged ecological damage and ordered the state to repair it by adopting additional sectoral measures by 2022. So here the French government took several steps by updating its national low carbon strategy, by adopting sectoral action plans in the field of transport and agriculture in particular to reduce emissions, as well as the new National Climate Adaptation Plan that I presented just before. So this is a very symbolic case in France that has reinforced the climate justice movement in France. And in this case, the court recognized that the states must take action in the fight against climate change, both in terms of mitigation, that is addressing the causes and reducing greenhouse gas emissions, and adaptation, in preventing the consequences and reducing the vulnerability of populations and natural system to climate change. Another case is the Grand Sainte case before the Council of States in 2021, brought by the coastal municipality of Grand Sainte, which is vulnerable to rising sea level. Here, the High Court recognized the standing of the municipality of Grand Sainte, mentioning that even if, I mentioned the court here, even if the tangible effects of climate change are only expected to fully unfold across the municipality's territory by 2030 or 2040, the Council of State based its decision on data published by the National Observatory on the Effect of Global Warming, which identified the Dunkirk area as having a very high index of exposure to climate risk. And the court highlighted the fact that the municipality of Grand Sainte is a stable territorial entity over time, and it has no intention or possibility of moving elsewhere. And so relying on this stability and the certainty of its exposure to risk arising from climate change, the court recognized its standing to bring the case. And here the court so ordered the states to take additional measures to meet greenhouse gas reduction target and to establish a monitoring procedure to assess future progress. With two deadlines in 2022 and 2024, with the submission of a progress report detailing this measure and their effectiveness. So the case set a precedent by holding the state responsible for Paris Agreement commitments. And in addition, the court made a reference to the provision of the United Nations Framework Convention on Climate Change and to the Paris Agreement, and took them into account when interpreting the French law. Recently, in October 2025, the Council of State considered that the state has indeed complied with the injunctions. However, this decision has been controversial, as some ONGs demonstrate that it was not in line with some recent analysis. In particular, they note that structural changes remain insufficient in the field of energy, transport, and agriculture. Regarding climate adaptation litigation, there is an ongoing case before the Council of State challenging the France's third National Adaptation Plan that I mentioned before, highlighting the need to establish a general obligation to adapt to climate change. Here, the Prime Minister and the relevant ministers are being asked to revise the plan and to adopt any necessary measures to ensure and strengthen France's adaptation to the effect of climate change. Here, the applicants have raised three important points. The first one, the need to define more precisely how vulnerabilities are addressed following the notion of social justice. Another point lies on the need to take health risk into account, and the link between health and environment is here brought before the court as a central concern. The case also stands out by asserting that the adaptation strategy must incorporate a balanced and sustainable management of natural resources and ecosystems. So the request expand climate litigation beyond mitigation and focus also on adaptation and resilience. And lastly, the case underscored the intergenerational dimension of the right to a balanced environment. And this has already been mentioned by the Constitutional Council in 2022 and 2023. Concerning biodiversity litigation, I would like here mention the pesticide case before the Paris Administrative Court. Here, some NGOs sued the state for negligence to its inaction in the face of biodiversity loss and its failure to regulate pesticides. So the court held the French state responsible for ecological harm resulting from outdated and inadequate pesticide environmental risk assessments, including soil, water pollution, and biodiversity loss. And the court has ordered the French state to review all pesticide evaluation protocols and authorization currently in force within 2 years. This one. So when it comes to criminal investigation, I would like here to mention the case against Total Energies, brought by some NGOs before the Paris Criminal Court. Here the complaint alleged that the board of directors and main shareholders of Total Energy should be held criminally responsible for their action and decision that contributed to climate change, which they took despite knowing they would cause significant damage to environment and biodiversity loss. The court dismissed the complaint due to a lack of sufficiently established proof. It emphasized that criminal responsibility requires proof of a deliberate violation of a specific legal or regulatory safety obligations. However, the court determined that the provisions cited by the claimant represent objective rather than legally enforceable obligations under criminal law. Additionally, the court stated that while greenhouse gas emissions are a recognized driver of climate change, such activities are not inherently unlawful, and establishing an environmental offense would require demonstrating a direct causal link between a wrongful act and specific environmental harm, a standard that, according to the court, was not met in the case. And lastly, the court stated that the complexity and multiplicity of factors contributing to severe climate events make it impossible to prove a direct causal link between Total Energies activities and climate disaster. So moving toward the conclusion of my presentation, I would like now to highlight some cross-cutting topics that case law referred to. The first one is the emphasis on protecting the environment for current and future generations. In addition, climate and biodiversity litigation increasingly argues that protecting ecosystem is essential to prevent health risk. The other point is on the necessity to integrate the notion of social justice in policy and strategy instruments. Cases are also emerging around the need for adaptation and resilience strategies. Court also require scientific evidence of climate and biodiversity impact to support claims. And lastly, there is an increasing recognition that climate change and biodiversity loss are linked. So to conclude my presentation, French state has been found responsible for failing to meet climate targets in several court rulings and has been ordered to adopt corrective measures in a timely manner. Case law emphasizes interconnection between biodiversity protection and environmental objectives. Furthermore, courts underscore the need of an integrated approach by linking climate action, biodiversity conservation, and resource management. And finally, adaptation and mitigation strategy must consider social justice and territorial disparities. Thank you. Thank you very much for your attention.
Thank you very much for your presentation. And we continue our journey through environmental litigation or climate change litigation. We move south to Italy. And Mrs. Chiara Venturini will address this matter. She is assistant professor at the University of Rome UnitelmaSapienza. And she also a PhD in public international law, in public law, from the University of Rome Tor Vergata. And she defended a dissertation on hypothesis of shared responsibility in operations involving armed remotely piloted aircraft. She's a member of the center, the Research Center on International Law, and a research focus on international responsibility, immunity, and sustainability of investment and energy law. You have the floor. Thank you.
Thank you, Professor, for the kind introduction. Good afternoon, everyone. So let me join in expressing my gratitude to the organizers of this brilliant event, and in particular, let me thank Professor Gemma Andreone, even if she's not here, for her kind invitation. So my presentation focuses on the analysis of the only 2 climate change cases brought before Italian courts so far. So as far as I know, there are just 2 climate change related cases. Before delving into the substance, a caveat is very important here. I'm not a private law scholar. I study international law, so if I say something that to you is self-evident, please bear with me. So the 2 cases share many similarities, but there's one big difference that I will delve into later on, and they're both brought before civil courts. They're both submitted by NGOs and individuals, and they will have the same, they share the same legal basis in the sense that in both cases the complainant use the article of the civil code, which is Article 2043 on not state responsibility, of course, but on responsibilities for damage, and they request as a kind of refund a specific performance. So they use in that sense, they use Article 2058 of the Civil Code. And this is a very important information to keep in mind, because it will lead to the very different outcome that both cases have. So the first case that I will address is Giudizio Universale. In this case, we just have a first instance judgment, and it's been issued in February 2024. The claim follows the Urgenda case model. So the defendant in this case is the state, so the Presidency of the Council of Ministers, PCM, so to say. The claim was submitted in 2021, and the claim argues that there is an international climate law that imposes climate obligation upon the Italian state, and therefore Italy has to compel with those obligations, lowering the emission. And in order to lower their emission, they should stand before the IPCC standard before 2030. In this case, the claimants not only sought to establish state liability for the failure to adopt the measure, but as I told you, they request the defendant to implement the measure, so to adopt a legislative act in order to comply with the international law obligation provided by the Paris Agreement and so on. So with all the climate change international law that we have. And in this case, the court takes a disappointing decision because she says it cannot be maintained that there exists a private law obligation for the state amenable to enforcement on part of individual to reduce emission in the way asked by the claimants. In this sense, the interest for which the claimants are demanding protection does not form part of the subjective interest protected by the law. Decision pertains to the ways and the timing in which anthropogenic climate change is to be handled, and that falls within the competence of the political organ that cannot be ruled upon in the present case. So what the court does, she shields herself under the political act doctrine. The court says that the claim essentially requires the civil judge to compel the state authorities to adopt a legislative and regulatory policies that are necessary to address the climate change phenomenon, and this is not possible. So the court does decide that she doesn't have judicial power to enforce and to request like the state to adopt a certain kind of legislation. Now, of course, this kind of judgment has been subject to many criticism because it's too conservative, because it's a setback. But what must be said is that in the claim, actually, the NGOs, which in this case is ASUD, is the name of the NGO, and some other individuals, asked the court to use a specific norm of the Italian Civil Code that doesn't really allow, as far as I know, to force the state to adopt a legislation. So what's the solution in this case? So actually, apparently so, the judge doesn't have jurisdiction. So Article 2058, second comma, gives the possibility to the judge also to provide as a refund damages and compensation for damages instead of forcing the state to adopt some kind of legislation. And that's what the judge can do by office. So they also cannot be forced to adopt those kinds of legislation, but apparently the judge didn't go that way. They decided that it was easier to declare that they had absolute lack of jurisdiction, and basically the case ended. It doesn't end, like it's under appeal at the moment, but that was the decision in Giudizio Universale. Unfortunately, the case was issued, the judgment was issued in February 2024. Maybe if the court could have waited, they could have listened to the Clima Signorin judgment. In that case, I believe that the European Court of Human Rights provides some kind of direction, stating in paragraph 412 that the task of the judiciary is to ensure the necessary oversight of compliance with the legal requirement. So in that sense, what I see here is that the European Court of Human Rights is giving a direction to the judges even when they are required to provide and to issue a decision where they are supposed to force the state to adopt a certain norm to fight climate change and to respect the international law obligation that they have under climate change treaties. Now, so this is the first case, very criticized. We will see what happens in the appeal, so in the second phase of the judgment. And these conclusions, so the lack of jurisdiction, leads me to the second case existing in Italy concerning climate change litigation, which is Justa Causa. Justa Causa is a totally different case in a sense that is a case where like we have Greenpeace, another NGO, and the defendant in this case is any SPS. So the model that the NGO is using here follows the Shell model that we have previously seen, and this leads to a very different outcome, and we will see why. So at the moment, the case is still pending. What I'm talking about here is a decision of the Supreme Court of Cassation, Suprema Corte di Cassazione, that issue a ruling on a preliminary question of jurisdiction, which is under Article 41 of the Civil Procedural Code, that provides the possibility for the claimants to ask to the Court of Cassazione to address which is the judge that has the duty to decide on the merit of the case. So which is the court competent to hear the dispute. And in this case, we will see that the Supreme Court of Cassation probably has studied international law and is aware of the climate change litigation happening now. So, previously on the fact, May 2023, Greenpeace and Recommon together bring the case before the Civil Court of Rome. The defendants, as I said, in this case are any SPA, but also the Ministry of Economy and Finance and Cassa Depositi e Prestiti. So MEF and CPD, we will call them. And what's the claim about? The claim is about the decarbonization strategy that of any, which is misaligned with the international obligation that and the scientific evidence, and therefore, like the claimant asked the court to condemn any to reduce their GHG emission, and in this case, they also allege that MEF and CPD, so the Ministry and Cassa Depositi e Prestiti, as controlling shareholders of any, share responsibility for failing to prevent any harmful practices. They are substantial shareholding according to the claim, and therefore they have the capacity to influence the company's strategic direction. Again, also in this case, the claim is founded on Article 2043 of the Civil Code and Article 2058 of the Civil Code. So again, here they ask for responsibility, for extra-contract responsibility, and they ask the court to order any to adopt the necessary measures in order to comply with the climate change obligation. The nature of this decision, the nature of this ruling is like just procedural. So again, the court doesn't delve into the merits because she cannot actually, but she says something very important. In this case, the court decides that is the ordinary judge that has jurisdiction. And the difference in this case is merely the fact that it's any, so a private actor that is the defendant in this case, even if the main shareholder of any are public institution, it doesn't matter. The thing here is that the relationship is horizontal. We're not going against the state. We're not imposing a political act on the state. Therefore, according to the court, this is just, and I quote, I have it here, an ordinary tort action grounded on the allegation of harm consisting in the violation of the right to life and the respect for private and family life. And in this case, it appears much easier to the court to decide whether an ordinary civil judge has the jurisdiction. Now, one comment on this case could be that actually the court, following the Shell model, opened the doors to judicial scrutiny over the conduct of a private actor. And this takes into account also the position taken by the ICJ in paragraph 427 of the opinion, where the ICJ affirms that the failure to adopt an appropriate measure to protect the climate system from greenhouse gas emission, including fossil fuel production, may constitute an international wrongful act. Now, obviously, what the ICJ says concerns state responsibility and not civil liability, and I'm very aware of that. But the fact that an international court states also that the state might be responsible where it fails to exercise due diligence by not taking necessary regulatory and legislative measures to limit the quantity of the emission caused by private actors under its jurisdiction is like a clear indication that the climate change litigation is kind of moving forward. And I do very much hope that the case that in this moment is at the civil court in Rome, and the judge will take into account what the ICJ has said, because that will lead to a very different conclusion from the one we had in the Giudizio Universale. And just to conclude, 2024 and 2025 are the year of the climate change litigation, and we are very aware of that. We made a symposium on the topic, so it's clear. In Italy, there are some difficulties, as we have seen, and the virtual example of Urgenda apparently doesn't work here. But there are current trends, such as Justa Causa, that might show that there is some room for optimism, even in Italy, even in case of climate change litigation. And with that, I conclude them.
Well, thank you very much. We move, I follow the order given to me. We move really to the Far East, to China, and until now, the three presentations were based a bit on the same approach. I do understand that with respect to climate litigation in China, there may be another component, another approach. That's with great interest that we will listen to your presentation, Mr. Nanxiang Sun. You are an associate professor and deputy director of Department of Research Coordination and International Cooperation at the Institute of International Law in the Chinese Academy of Social Science. And you are specialized in cyber law, and you have published extensively in this matter, this from cyber law to environmental law. Thank you. You have the floor.
Thank you, Chair, and thank you very much. And also thank you to President and Director Germans for the invitation to invite me to here to have this introduction. And in my opinion, I think the cyber law and as well as this environmental is similar, because they all these two subjects is the new emerging subject and for all the world. So they have a lot of similarities and together. And also, so my major is international law. So I have known some more about the environmental protections, regulations in international as well as in domestic spheres. So, and thank you again. And my topic today is about the trend in climate change litigation, and I will share this climate change litigation experience in China. And we all know in September 2020, at the general debate of the 75 sessions of the United Nations General Assembly, and China made the first commitment to have this green gas emission peak before 2013 and achieve carbon neutrality before 2016. This we called it the dual carbon goals. With the proposals of this statute, and China have initially built a dual carbon policy system from the central to the local level, as well as from and promulgate a lot of legal documents. So, and from a legal perspective, the China's dual carbon legal system is mainly based on the Constitution of China, the Environmental Protection Law of China, and the Atmosphere Pollution Prevention and Control Law of China, and the Energy Conservation Law, as well as the Forest Law of China. And in our previous experience, that the total amount of these carbon emissions generated by production and living activities is directly regulated through administrative regulation and direct market regulation. And however, and China nowadays is exploring another approach to control this climate change problem, and which is through the litigations and measures. And why and China and choose to the public interest litigation and to protection environment issues, and especially and initiated by the procuratorate. This is the government department of China, because we thought that it is an effective means to addressing the impact of climate change by the public institution. And first, climate change involve and maybe global and long-term issue, and the public institution and can coordinate resource from all the parties from a national level, as well as to promoting cross-department and cross-sectoral carbon reduction and emission reduction measures. And the second, and the public authority, and they have a lot of, they can ensure that it is public interest litigation not only has a legal basis, but also it can be enforced in practice. And so this is a very important reason that China use this public interest litigation measure. And third, as a legal supervisory body, and this public institution can detect and prevent greenhouse gas emissions earlier. So this is the reason that why and China they want to try to use these public interest litigations and to control the climate change issue. And also China have promulgated a lot of legal documents and relating to this type of litigation. And as earlier as 2014, Article 15.3 of the Administrative Procedural Law of China have stipulated that when a party file against administrative action, and they can also request a legitimate review of the normative document involved. And so this is the first mode appeared in the China's litigations about environmental public interest litigation. And also, however, and the existing legal basis only includes and the two provisions and a lot of issues that need to be handled with. Therefore, the Chinese Supreme Court have issues at least two opinions directly relating to the public interest litigation. And one is in 2021, and the Supreme People's Court of China issues the opinion. And this opinion propose exploring rules for adjudicating climate change response cases and marking the judicial system proactive response to climate governance. And in 2023, and Chinese Supreme People's Court issued another opinion, and it regulated outlined requirements for adjudicating environmental infringement disputes relating to greenhouse gas emission, and especially methane-led ecological restorations can address environmental damage caused by greenhouse gas. And also, in the last 2 years, in 2024, and also the opinions relating to comprehensive green transfer or mentions of economic and social development is an issue. And in 2025, and it's this year, the draft of the law of the People's Republic of China on public interest litigation and was submitted to the Chinese Congress, and making a crucial state in the special litigations of Chinese style systems for safeguarding public interest as well as the climate change interest. So, and during these almost 10 years, and China's have issues and a lot of cases relating to this climate change. And according to the data from the China's judgment online website, from 2021 to 2023, China's court heard 31 public interest litigation cases related to the air pollution. And of these 31 cases, 19 cases were civil public interest litigation cases. And the plaintiffs primarily seeking for the cases of infringement, and also to eliminations of the environmental danger. And also they have the 8 cases and relating to relating to the ecological restoration issues, and 12 cases relating to administrative public interest litigation cases, which is the plaintiff is that the plaintiff sues specific administrative action and demanding that the court order the administrative agency to fulfill its responsibility. Therefore, and in China today, they have a lot of experience relating to these public interest litigations with climate change. And what about the legal basis for climate change and public interest litigation? And the first is who is the plaintiff? And according to the Article 15.8 of the Environmental Protection Law of PRC, it states that the two kinds of social organizations and can be sued in the court. And the first is that it's the people's government, it's the government, and they at the civil level, city level, and they can sue these cases in the court. And the second types of plaintiff is the public welfare. This is the organization, that is the NGO, and if they have touched at the environmental protections and issues, and they can also be the plaintiffs of the court in this public interest litigation. And the second is what is to protect in these legal remedies. And it states that this type of climate change, they should be constitutes the public interest, and only the issues and to be constituted to public interest that and this interest could be sued and pursued in the court. And this is the problems, the legal problems, that's how to divide the public interest. And at least, and public interest in China it includes such as the act maybe they have some actions or inactions that cause the pollution of the environment or damage to ecosystem. Also, they will have a significant risk of hunting the public interest. And also, the court will analyze and let this which types of public interest to be pursued in this court. So it depends by case. And the third one is about the liabilities in this climate change litigation. And at least it have 4 types of liability. The first one is the liability for ecological restoration. This means that even if the damaged environment cannot be completely restored, alternative restoration measure can to be used to compensations for the damage caused by this tort feature. And also the second type of this liability is the personality restoration responsibility. It means that the plaintiff can ask the polluters to apologize to the public. This is the second type of responsibility. And the third type of the liability means the preventative liability, which means that even this cause there is no approach or is no relative and the plaintiff requires these polluters that they cannot pollute and in the future. Also, the last one is about the compensatory liabilities, and the plaintiff can also claim damage for the loss caused by the loss of ecological environment, something like that. So, and also the last one is about the cost allocation, and the court will support the plaintiff request for the defendant to bear the following cost, such as the cost for ecological and environmental damage investigation, assessments, and so on. And the second is the reasonable expenses incurred in cleaning up pollution and preventing the occurrence and spread of damage. And the third one is the reasonable autonomy fee and other reasonable expenses incurred from this litigation. As I have stated before, and China they have several cases relating to public interest litigations on climate change. And in China, they have the two types of this public interest litigation. One is about the administrative public interest litigation, centered of the essence or inessence of the administrative entity. And the second one is about the civil public interest litigation. They will focus on the environmental damage compensation by the private person. So they have the several typical cases and relating to this one. And in 2013, this is the first case and of China's public litigation interest, public interest litigation. It is relating to one NGO in China. They have sued the accompanied in the Chinese court, asked to cease and reduce the environmental damage. So in these cases, they have the two critical issues relating to this case. The first one is whether this NGO and could be a legitimate plaintiff in China's law. And the second is that the mediation, the methods of mediation is suitable to handle about the environmental these cases. And towards the first issues relating to the plaintiff and And the court said that because even though it's an MGO, but it have its obligations, and also they have the right to sue in China according to the Environmental Protection Law of China. And but the second measures it seems that the litigation and mediation and as well as arbitration, all these three measures they have benefit for the disputes settlement and relating to climate change. So in 2023. And this case is settled by the mediation, and the plaintiff they have come to an agreement with the defendant and about to reduce about the environmental losses. So the next topic I want to share about is that the major challenges and maybe facing public interest litigation on climate change in China. They have a lot of difficulties in the legal reasonings and legal applications in China court. And for example, and these public entities, they face significant challenges, and when they initiate public interest litigation to address climate change, because the complexities of climate change issue made it difficult to prove the causal relation between the environmental damage and emission, and also to establish a suitable plaintiff is quite difficult in the judicial proceeding, as well as the availability of judicial remedies is difficult to determine. I think some these challenges have posed and by the previous my colleague and preview and statement. So I will look here. And also, so the last one will be what's the futures of China's what's the futures of China's public interest litigations on climate change. I think the first one is that at the substantive law level, the rules of climate change public interest litigation could be written into the Chinese environmental and ecological code, and to made it solved legislations for these special and specific litigations time. And the second is at the procedural level, China's it should be explored how to introduce the application of preventive litigation and class action lawsuit, as well as to establish technical standards for climate change assessments to solve the problem and of this proving taxation. And also, China maybe will encourage more social organization and no trust about the public entities to file lawsuit against companies for actions they have or may cause climate change in future. And the last one is that also the improvement of the civil public interest litigation system will be approaching, and such as to make the salt and legal liabilities, as well as to pursue define clearly about the public interest in these litigations. And so I think in the futures China today they will establish a sound and comprehensive climate change litigation system in future. And thank you very much, and thank you for attention. This is my opinion. Thank you.
Thank you for your presentation, which was extremely rich, and you nearly stay within the 20 minutes. Now we complete our journey around the world. We come back to our longitude, Greenwich Meridian, that's UK. We will hear a statement, a presentation by Monica Feria-Tinta. You are a barrister specialized in public international law, and you practice from 20 Essex. Your practice covers environmental and climate change cases, and you appeared in all the climate advisory opinions proceeding before international courts. You are the Barrister of the Year's finalist at the Lawyer Awards 2025 and the Times First Lawyer of the Week in 2025. You have the floor. Thank you.
Well, thank you very much for the floor and for the patience in listening to all of us on a long day. I think that it's been quite interesting, the morning discussions on international law, and I see a little bit my intervention bringing it down to the UK specifically. I was invited to speak also about other possible common law examples, and I picked New Zealand in particular, and you will see why. And when I was invited to speak about perhaps the US, I declined, because the US is a world in itself. And I recently was in discussions with a very leading scholar on climate change, who is at the Sabine Center, and he said international law is irrelevant to what is going on right now in domestic courts in the US, which is just about interpreting a statute. And that was quite striking, I must say, when I heard that coming from who said that. So let me just make 4 points. I'm not going to really describe all the UK system, but rather going to make perhaps comments on 4 specific areas. The first area is what has to do with public law, and a couple of examples on judicial review. The second area that I'd like to comment on is about corporations and any climate change related cases on that. The third area has to do with an example of transitional climate litigation that is against renewables. And finally, I like to make remarks on biodiversity-related litigation, and some very exciting developments are taking place in the United Kingdom. So this morning, starting with the first, this morning we had Judge Caracciolo telling us about the advisory opinion by ITLOS and how Article 222 had established that there were responsibility on the part of states to adopt laws, regulations, etc., which had to do with being able to regulate a system so as to prevent harm that was causing different sectors, including aviation, shipping, etc. So how do we assess what's going on in the US? I'm going to start with a good example, and I'm going to give you a bad example then. A good example, oil exploration, the Finch case. Well, this is not a case that started as a climate law case. This case actually started as a planning case. Now, Finch went all the way to the Supreme Court. Now, for you to understand climate litigation in the UK, you have to take into account one thing: how much it costs to be in court for one day in the UK. So on a public law type of case, and I don't know whether this may be comparable to any of the experiences of you in your own systems, I would say that a day in court in the UK would cost approximately, and this is just a straight public law case, so not large teams, just very small teams, about £60,000 on a day. So if you lose on a day, you have to pay your costs and the costs of the other party, and that we are talking about £120,000 within 14 days. So what does that mean? That parties have to be extremely careful to bring cases. So it's not just like possible for anyone trying to bring a case to actually bring that to courts. So a human rights law claim, purely human rights law, we haven't seen that yet because of this issue. But what we have seen is that other types of judicial reviews have come up. In the case of Finch, this was an oil exploration in an area that is pristine and wonderful in England, Surrey. I live in Surrey, so it was quite close to my heart. The person that brought the case argued something very specific, and it was the following. When you have an oil exploration project, the impact assessment has to consider not just the project itself when it comes to impact, but the burning of the oil that that project will bring about. And that has to be considered in the assessment, and whether to grant license for that or not. Now, this went all the way to all the different stages in litigation. And when it arrived to the Supreme Court did something, and this is previous, before we have had the recent ISGI decision, etc. The Supreme Court in the UK said that Scope 3 had to be taken into account. So basically, that the burning of the oil that that particular company will be responsible for had to be taken into account. Obviously, the company in question had argued that really that couldn't be the responsibility, that was the responsibility of everyone that was buying the oil for their own cars. But the Supreme Court didn't agree with that. And this was a major decision because you can see the difference of approach with the case that I touched on in the morning, which concerns Norway. And it's very straightforward because so license couldn't be granted. And the answer was no. The case was crowdfunded, meaning that it was an individual, a member of a community that took it up. So it was not coming from an NGO, it was coming from a member of the public that basically changed the law in the UK via that Supreme Court case. Now, that obviously will have clear consequences for any other case because it's the Supreme Court. And it's very interesting to see how it may apply in the future. That is about a good development. However, and let's move on to airports and let's move on to aviation in the UK. What has been happening? It's actually very much the opposite. At present, we are living in the UK an era of expansion of airports. A very important case that recently was decided some years ago concerned the expansion of Heathrow. There were arguments on climate change, there were arguments on the Paris Agreement, there were arguments on some human rights, which were not taken further. But when the Supreme Court in the UK decided this case, basically said, well, but the assessment and the target at that time was considered not to be 1.5, but rather, that at the time that the assessment was made, the law for the court was not clear, and therefore the state had made the correct assessment, and therefore, because of a temporality issue, the project could go ahead. So it was approved. So I was involved just the week before coming here on a case that involves Gatwick. Now, Gatwick Airport is a leisure airport, meaning that the majority of flights are all related just to people that are traveling for leisure. And that is an airport that now has been granted an approval for a expansion by the Secretary of State. So this is where international law and domestic law now are clashing, because you see, the UK doesn't see how this contradicts, for example, the obligations that ITLOS just clarified. And economic interests are playing a key role. So in the balance of what are the key elements to take into account, the Secretary of State would say, I have taken into account human rights and climate and everything into account, but the economic interests are preferred because it's important for the economy, et cetera, et cetera. So I think that this is where the direction trajectory is taking us, and I think it's very worrisome, because the kind of barristers that plead these cases are usually plain planning barristers, and consider that all these discussions about climate law and what the international courts have been saying is irrelevant, because everybody knows that climate is a pressing issue, and what matters is really how planning law is interpreted. Now, is international law relevant at all in a domestic system such as a dual system like the UK? Because the UK needs to incorporate law, international law, for that to be properly addressed by courts. I would say it is. We have a ministerial code, so ministers have to obey the rules of the ministerial code, which means that international law in the ministerial code is a relevant law that they have to comply with in actions, determinations, etc. But we haven't seen that being used enough. So I worked for the Foreign Commonwealth Office for 1 year, so I can say that it is an important code. Yet when we come to see litigation, we haven't seen that this has been used in the context of climate, and I would imagine that this has to be used in the future, but it has to do very often with who is pleading a case. And so this is a little bit of a, we will have to watch that. So far, this litigation against expansion of airports is just starting, so we are to see what's going to happen, but I think it will be very frustrating to see that divorce between commitments and clarifications of international law on the one hand when it concerns this particular industry, and on the other hand, practically seeing all the airports in the UK expanding at present. So Gatwick has been given the yes, Luton has been given the yes, City Airport has been given the yes, and Heathrow has been given the yes. So I think it is a very important area to watch. Moving on quickly to corporations. Well, here I think the Shell case really set a very important precedent, and what I like to say about that very quickly and why it's relevant to the UK is because torts, which is the law that is applicable to private entities, torts was interpreted in the Shell case through the gateway of a specific convention that we have in Europe, which is Rome II. And what the court said is that, yes, you could create a harm in the climate context, which was an environmental one. And one of the key questions there is, what gives rise to the damage? Is it, Shell said, is the policy. And Millefunsi said is the policy, but Shell said no, it's not the policy, it's actually the emissions. And the idea was that by that they were going to make it more complex because the applicable law could be a myriad of laws. In that case, the court interpreted Rome II, Article 7, in a different way, agree with the claimant, saying that what is important here really is the, what gives rise to the harm is the corporate policy. So from that perspective, once we have at least one precedent of that sort, is relevant for the UK as well. But we haven't seen yet I would say, a case that has reached a court for a decision similar to that one to actually come about. And the reason, I would say, is not lack of creativity, but I think a big fear concerning costs, because these are group litigation cases which are extremely expensive. 1 year, it can be £1 million. So considering the costs of the other party, that can be quite significant. But there has been one very good development in New Zealand, and that's the Smith-Fonterra case. And why do I want to emphasize that? Because one of the frustrating things to realize, at least for me, when I was advising possible plaintiffs, was that the lack of precedent. And that some colleagues of mine said, well, there is no precedent in our system. And my position was that torts in common law has started from zero. So we have had the case of Donaway versus Stevenson. I don't know whether any of you know about that case, but it had to do with the following. It had to do how torts started in common law. Someone drank a beer, and there was a slug in the beer, and that was the beginning of torts law in common law, because there was this duty of care that was set to be owned by anyone, a corporation, for example, putting a product out there, to those that are the public and to whom this is addressed. So you didn't need to have a contract between the two parties. So what Smith and Fonterra said, and this was a Supreme Court case from New Zealand, is that in the climate context, this principle applies. So there is duty of care. It is possible to bring a tort case for harm in the context of climate change. And this has changed completely now. The possibilities, it has opened the door. The Supreme Court in New Zealand has opened the door in the common law to make a case arguable. Because at this point, this is where we are, to say that it is at least arguable. There is not yet a decision on a trial, but at least the case is not charged on the basis of jurisdiction, on the basis of, can you argue such a case? So I would expect that it will be the next step for the UK to have a case in courts, in commercial courts, on a similar basis. It will be necessary. We have had a lot of case law that deals with responsibility of parent companies, but it has always been on very traditional basis of environmental law responsibility. Now, moving on quickly to the case of transitional climate cases. So some renewable companies have seen a huge opportunity for wind farms in the UK. But this is why it's not just a matter of whether it's fossil fuels or another type of energy. It's a matter of the principles of respect of human rights and environment. Because in this particular case, which is a case that arises from Wales, what is interesting is that a company was given the go-ahead authorization to assess the possibility to just plug pylons all around an area that is pristine and is very, very, rural in Wales, and where there's dark skies, etc. It's very scary for the majority of farmers that live there, because it's about 300 farmers that just had people entering their properties, violating arguably human rights. And this case had been now been filed before the High Court for review of this type of intrusions and violations of human rights for the sake of green energy. So it's currently just being processed. Now, but it is a very important case that I think is going to create a very, very important precedent in the context of what is the way to develop projects of renewables in the UK. And fourth, the category that I like to address on biodiversity is the growing scenario of rights of nature in the United Kingdom. And this is coming out of a crisis, really, because the majority of rivers in the United Kingdom are polluted. It is so deep ingrained in the consciousness of people that they don't want that at present there has been a number of examples where councils, regional councils, are asserting the rights of their own rivers via a number of declarations. Now, this may evolve to a point where we are talking about several different districts may do the same, and this may end up being an act really in the UK if these different constituencies are actually asserting an ecocentric approach to protect nature. And we have in Europe already a model, and that is the Spanish model that accepted that a lagoon, a Mar Menor, is a natural body entitled to rights. At present, I am acting for a Mar Menor before the European Court on Human Rights on the basis of breaches of due process rights. And it's going to be interesting to see whether Strasbourg is going to have the same approach whereby it has accepted that corporations or legal persons have protections under the European Convention on Human Rights, whether the same principle applies when the legal person is a natural body, such a lagoon. So I want to stop there, and I want to really hope that perhaps there is some questions, because it would be interesting to see what you think about these different developments also in the United Kingdom. Thank you so much.
Yes, thank you for all the participants in this panel. It was very, I would say, very enriching, very interesting. And since you complied with the 20-minute rule, there is a bonus. There is a debate. Now, there are questions and answers. We have 30 minutes or 20, 25 minutes. We have enough time for questions. The floor is yours.
Thank you so much for a very interesting panel. It's so interesting to see how many different national perspectives can actually impact on a problem that is about the respect for international law, and that we have so many different answers to the same kind of a question. I have several questions and comments, but I'll be brief. For Monica Feria-Tinta, I would like to ask you about the possibility to use the Human Rights Act to, I don't know, make the government accountable, or is that the principle of parliament sovereignty is preeminent, and so it is not possible to go before a court and actually ask for an injunction towards the government?
Yes. So in the Heathrow case, there was an argument on human rights, on a human rights basis, but it was done at the level of the High Court. And when it went up to the Court of Appeal, it was abandoned. Then when it reached the Supreme Court, they tried to revive that argument so that they could go to Strasbourg. And the court didn't allow that because it was not on appeal. So once it went that route, it only had to do with the planning aspects. So no, we haven't had yet a judgment on a case that raises just pure human rights arguments, but there has been already some cases that have started. Now, sometimes cases settled, and it's very often the case that parties explore that. Because there's, for example, a case on a group of people that have disabilities and that live nearby an area that is right now quite eroded and would have required action, climate action. And so if there can be a resolution that is prior to actually a long process of judicial intervention, probably that will be the preference of parties. But I think that what is key here to mention is that, which is a little bit frustrating from my point of view, is that we talk a lot about article, so the right to life in the context of climate effects that are negative. But you see, in the European context, funnily enough, so far, they appear to be not a possible case unless people are dead. So, because the gate has been usually Article 8, it has been intrusions on the right to privacy, etc., when it comes to environmental harm. Well, I find that quite contradictory, that so far we have not seen any example where Article 2 can be actually found to be breached in a context where people are having serious, or perhaps where the obligations of the state can show that require positive action was not taken. But not to the level, you know, so we are still just looking at the right to life from a negative obligation point of view, so it's not to kill. But in the Inter-American system, it's completely different, and I believe that that is a very interesting distinction. They don't consider issues of climate effects only come in via the gate of right to privacy, etc., but fundamentally right to life.
And I also have two other brief comments. I'll leave the comments and then I'll pass the microphone. Just very quick. It's just quick.
Okay. Listen your two questions. Okay.
I wanted to ask Otto Spijkers, what is the actual weight of future generations having been bundled in the decision? Like, does it actually play a role in the practical outcome of, or is it just a symbolic question? And just one last remark for Chiara Venturini. I wanted to ask you if the claimants in the Justa Causa case actually relied on Article 2059 asking for moral damages, because when it comes to human rights litigation, it's actually very difficult to demonstrate economic damages. But I also know that the Court of Cassation in the grand composition, let's say United Sections, actually ruled out the possibility of using Article 2059 for the compensation of ECHR related damages. So I wonder if the claimants actually use that kind of option. Thanks.
Yeah, very interesting question. So I think you have to distinguish the approach taken in the Urgenda litigation and then the approach taken in the Shell and the fossil-free litigation. So in the Urgenda case, the court basically said, we don't need to look at standing with respect to representing future generations, because it's already the present generation that is suffering from climate change. So they very conveniently avoided all these difficult philosophical questions as to whether a foundation can represent the interest of future generations. But indeed, as you rightly mentioned, in the Shell case and in the fossil-free case, the strategy was different. There the judges bundled the interest of both present and future generations into one bundle, basically saying, well, they might not be exactly the same, but they are fundamentally the same, which is a bit of a strange conclusion, you might say, because there is a difference between our interest and the interest of people who will come to life in 2 centuries. We may have different interests. But for the court, they were sufficiently similar to bundle them. And then your follow-up question, which I also find very interesting, you ask, so what did the court say about these future interests, these interests far, far away? And actually the court said very little about them. So both in the Shell case and in the fossil-free case, it was really about climate change affecting us today. And the court said very little about the distant future, which, yeah, it is a bit surprising. So I very much welcome your question.
So thank you for your question, and that helped me also to clarify something that maybe wasn't that clear in my presentation. So the claimants in both Giudizio Universale and Giusta Causa use Article 2043 and ask the judge to assess non-contractual liability under the Civil Code. And then they asked for reparation. And they asked for reparation according to the article that I mentioned, which is 2058. So they basically say to the judge, order to the responsible, so the defendant, to adopt a conduct in order to solve the issue. And what's striking is that the article that you mentioned, so moral damages, doesn't appear, neither in Giudizio Universale, neither in Giusta Causa. And another striking aspect to me is that they use as like subsidiary mean another article of the Civil Code, which is 2051, and basically that's objective responsibility for custody. And in that case as well, they refer to Article 2058. So again, the state or any SPA, Ministry and Cassa Depositi e Prestiti should adopt the correcting conduct, so to speak. And I guess the point here is like how the claim is structured. So basically, Assud and Greenpeace, they are not looking for damages. They're not looking for, some kind of compensation. They want a political action. And that's why in one case it doesn't work because the judge says, I haven't got any jurisdiction in this case. I cannot oblige the parliament to adopt a norm. While in the second case works because it's horizontal. So it's easier for the Suprema Corte di Cassazione to say, yeah, the tribunal can rule on that because it's easier. And I think answer to your question. So Article 2059 doesn't appear, but I think it's because of the claim, how the claim is structured, I think.
We can take perhaps two questions and after that answer. Yep.
Okay, thank you for giving me this chance to ask a question. From our morning session, I find that from our distinguished judges from the international tribunals that we find more obligations of conduct than the obligation of result if I understand right. So I'm thinking of about the climate change causation, because I think that if we finally figure out and resolve the problem of climate causation, it is could help me very much to fulfill the obligation of result. So I put this concentrate and hope to our domestic courts. So this is a question to all 5 speakers representing different countries, so to UK, to Italy, to France, to China, and also to Netherlands. So my question is, I didn't read through and made deep research to the domestic courts and reflected in the climate litigation in different countries, but I think that still the judges reflect more obligation of conduct than the obligation of result, and quite similar with the international tribunals. So I'm asking to our 5 speakers that do you feel or smell some some sense or flues that the domestic judges in your countries already try to establish some threshold or elements that to make a link between the behavior of this kind of climate damages made by the companies and the climate, the result. For example, I could use the case the KLM. So I find maybe a midterm roadmap to establish this kind of climate causation. That is, so for example, is there any argument made by the NGO that okay, this falseful advertisement by the KLM actually made a quite adverse effect to the national determined contributions by the Netherlands and greatly reduce the national commitment. And this national commitment and establish the climate position. But I think Otto know my answer. Am I made a clear explanation? So you know my meaning. So the apparently, so the judges will say, okay, the KRM, you didn't fulfill your obligation of conduct, that you should reduce the carbon dioxide by your. So, but the thing is, this still the obligation of conduct instead of obligation of a result. So if we could at least to use some cost and benefit analysis and collaboration with some interdisciplinary work with economics, with accounting, and then to improve that. Okay, this fourth advertisement and also the bad behavior by the KLM actually could reduce at least 20% of the NDCs made by the Netherlands government to the international obligations committed to the Paris Agreement. At least we could make some steps towards to the real fulfillment of the and also the demonstration of the obligation of result. So my whole question that is, is there any threshold or element or technical standard already established or you smelled in different domestic courts, the judgments, among these so numerous climate litigation? So, thank you.
I will give the floor to each participant, perhaps connected therewith, because you refer to the pronouncement of international courts. It's probably interesting also to hear from the panelists what is the role of international law in the decisions of the different courts, because we heard that before Dutch courts, human rights is invoked and an alleged breach of Article 2, for example, or Article 8. That's one side. In France, international law is used to interpret. International law is used to interpret national law. But is there any other form of reference to international law? I know it's a dualist system in the UK, but customary international law could be invoked. We could connect both questions, if you agree. Yeah.
Yeah, let me first address your more specific question. So both the cases I referred to, KLM, Shell, but also ING, basically it's about these scope 3 emissions. So it's greenhouse gases that are emitted by people who use their products. And so people who fly an airplane or people who drive a car that is run by Shell petrol. So both KLM and Shell, they always make this a bit childish argument. They say if people no longer want to fly, if people no longer want to drive a car, then we will stop offering them flights and we will stop offering them petrol. So it's really not our responsibility, it's the consumer. We just deliver them something that they want. If they stop wanting it, we will no longer deliver it. And then about the greenwashing, that's also very interesting. That's not really legal research, but I would, of course, be very interested to see that now KLM has stopped these advertisements because the court told them to. It doesn't seem like people are flying less. So actually the number of flights is only increasing. So I wonder if KLM would advertise about how terribly polluting their aircraft are. I think people would still fly. And so I doubt a bit the influence that this advertising has on the consumer, but of course that's not legal research. And same for Shell. Shell now is advertising, basically urging people not to use their products, basically urging people to drive electric cars instead of petrol-driven cars. there's Shell advertisement to this effect, basically saying, don't buy our product. It's very interesting. Oh yeah, and then about your question. Yeah, so I think the Dutch courts, they very liberally use international law. So they refer generously to the European Convention on Human Rights, basically treating it on a par with Dutch domestic law. But they also refer to UN General Assembly resolutions as if it is binding international law. Like the UN resolution on a healthy environment is treated in the same way as a treaty by the Dutch courts, which I find very interesting because officially it's a non-binding recommendatory resolution of the General Assembly. And the Ruggie principles, they are invoked against Shell as if this is a treaty containing binding commitments for Shell. So very progressive.
Thank you for your questions. So in France, we have two laws that provide for the reduction of greenhouse gas emission and provide for a threshold of 40% by 2030, and another one which set the target of carbon neutrality by 2050. And in the case of Affaire du siècle, before the administrative court of Paris, so the state has been held responsible for inaction and for not for failing to reach this threshold. And so it has been ordered to take additional sectoral measures to achieve the goals that has been included in both legislations. So it's an obligation to repair by adopting additional measures. In the case of Affaire du siècle. And on your question, Professor Gautier, yes, in the case of Grand Sun case before the Council of State, the court referred to Paris Agreement and the United Nations Framework Convention on Climate Change to interpret the French law, and this is quite new in this case to interpret the national legislation under international convention, so following this decision, other courts will now rely on international convention, which has no direct effect in the French legal order to interpret a national provision. Thank you.
So thank you for both of your questions. Relating to the first one, the thing that I can say is that in both judgments, the claim refer to IPCC standard, and they use those standards in order to ask to the defendant to adopt the right measure in order to mitigate. So, for example, in Giudizio Universale, Italy should reduce the emission by 92% before 2030, while the goal assumed by Italy, according to Paris Agreement and DC and so on, was like a reduction of 36%, and that is the difference. But in both cases, the problem is that, that they're not on the merit. So the first one is a declaration of absolute lack of jurisdiction, and this means that there is no judge, no judgmental authority that can pronounce on the case of Giudizio Universale, while in the other case, the Suprema Corte di Cassazione says we have jurisdiction, while the tribunal has jurisdiction, so the case can go on. While the use of the importance of international law and the use of international law in both cases, again, in the first case, international law is very widely used and by the claimants, of course. They use the Paris Agreement, UNFCCC, IPCC reports, and basically they say Italy has international law obligation, we have to respect them. But yeah, it ends as we know it, so I don't know. But the very interesting thing is what the Suprema Corte di Cassazione does in an obiter dicta. So they say, yeah, the civil tribunal has jurisdiction and so on, but it also says, and I had it here, the civil judge will have to assess if the international obligation exists on private actors. And that's interesting because it uses the European Article 2 and Article 8 of the European Convention of Human Rights, but also obligation coming from international climate change law. So that's interesting, but it's an obiter dicta. So we will see what the judge will do with that. I hope much, but I don't know. Let's remain optimistic at least.
Thank you, Professor Chen. Thank you for questions. Yeah, because you will know about the Chinese practice, and I will share some other things relating to maybe the conduct and the results. And as in the WTO cases, and as well as in some cases relating to international tribunals about these environment protections. And I think the two principles are very important. The first one is the evidence of scientific proof, because nowadays we cannot observe that the future will be happened. So due to that, and all the decisions made should be based on the current scientific development. And so I think this is the first thing that all the decisions nowadays they have some weakness because they cannot witness the future scientific development. However, I think it just come to a consensus with all human beings that what we want to be. And I think it's the first maybe it's the principle when to think about maybe how to control the results or to control about the measures. And the second principle, I think, is the risk prevention principles in international law as well as in the domestic law, and how to mitigate the risk. And I think it's very important, and that's why we want to control about the measures, or rather name the results, because they have some maybe precedent, and we can know about the future's risk. Such as you have mentioned that about the technical standards, and that's very important, and it has just reduced the risk of the SPS or the TBT. And however, it is not totally to abandon the risk. It has just controlled the risk at maybe acceptable terms or acceptable fear. This is what maybe our previous authority said, how to balance between the rights as well as the development of the environmental atmosphere. And I think how to balance the values is the backbone of the case. About the international case as well as the domestic case, and then they have to handle with. So this is my understanding. Thank you.
Yes, so on these issues of conduct and result, I think it's quite interesting that in the case of the United Kingdom, as soon as the ITLOS advisory opinion came out, there was a direct effect. So, for example, the convention is an unincorporated treaty, right, in the UK. But one of the key effects that we all saw immediately was that the North Sea had been opened for licenses, oil exploration. And as soon as this advisory opinion came out, probably on the basis of advice, the UK withdrew that. I think this is it's interesting because the science has been quite clear about new exploration licenses. New exploration has been tied to, obviously, the possibility of exploitation. So although it was not acknowledged in the advisory opinion as an obligation of resort not to grant, so it's refraining from granting, nevertheless, the analysis was sufficient to actually flag a warning, a possible risk there. I think that the ISGI decision has been even clearer in that sense. And that's why potentially, at least in the trajectory of the UK own approach, would have been that licenses wouldn't be given in those cases. But I think that's why I mentioned in the morning, it's very frustrating to see the analysis of the European Court on Human Rights. I do see inconsistency because the court was relying on an issue of domestic law and when does an impact assessment takes place. It's completely ridiculous to think that you can grant licenses and then look at the effects later. And for many reasons, including the connections with investment law as well, which we have not talked about it at all in this so far today, but it is crucial. The colleague that addressed the situation of the Inter-American system said that it was a kind of a propaganda kind of effect. I don't quite agree with you, because the moment that the Inter-American Court has said that there is a peremptory norm, it put that particular protection of the climate in a higher sphere. So what happens? Only that specific court addressed investment law. And what does that mean? When there is contradiction of obligations, there's one that trumps the other. Why? Because Latin American jurisdictions have a lot of issues with investment law. So there has to be a way to integrate these contradictory in appearance obligations. We have seen that the Netherlands has faced, because of all the different coming to well, the state taking into account, very importantly, climate law and adapting, we have seen that it's been challenged and sued by corporations. So I think that, in other words, we are seeing a moment where a lot of things are changing and states are taking steps both domestically and internationally. The UK withdrew from the Energy Charter Treaty. Over there also, the Netherlands has taken a number of steps so as to be able to regulate internally the domestic legal system. In the case of the UK, customary international law is directly applicable as part of the law of the land, in principle. But the problem is when there may be contradictions with the statutory law. So that's a little bit more complex.
But that means that customary international law was invoked in the cases brought before UK court or not? No, was it?
Unfortunately, so far.
Yes or no?
Well, it's not that straightforward. So it hasn't been pleaded because it was not considered the issue, the point. So unless one can bring that into materially being relevant to construe a particular statute, it will be hard to be considered.
Thank you. No, thank you. I think since you referred to a presentation of this morning, and I think the use cogents here was addressed more the way it was articulated and presented, the fact that it would protect the environment, that's another question, and whether it's complied with, that's again another question. But I think
thank you for your comment. Okay, my position, of course, is that the declaration of the prohibition of causing irreversible damage to the environment is a peremptory norm is quite important because of the, I explained at the end, of the conventionality test. But the point in my intervention is that the court declared the existence of a peremptory norm, but didn't say nothing about consequences. If I say that something is peremptory, I must say which are the consequences related to that peremptory norm. It's very deductive to say the norm is peremptory because it's necessary. I agree that the norm is peremptory because it's necessary, because there is a functional link with human rights. But then I must say which are the legal consequences attached to this declaration. And the court limited this position by saying states should cooperate. I mean, this is quite a contradiction in terms, because if something is peremptory, it's not possible to declare that states should cooperate. Okay, thank you.
Thank you. I think we are approaching the end. If it's not the end already, Gemma Andreone confirms that this is the end. I wish to thank all panelists. It was for lively discussion.